Alrighty, party peoples of the interwebs, there is an expression from rice paddy to rice paddy in 3 generations, and something tells me Isaac Hayes III is heading right back to that rice paddy. Viva Frei, former Montreal litigator turned current Florida rumbler. I'm a little late to this story. It was in the news last week about Isaac Hayes III suing the Trump campaign for unlawful use of his father's song without a license. There's obviously a lot more to the story, and I knew it from the get-go. But getting back to that expression, it's a wonderful expression. Every culture has one of their own, from rice paddy to rice paddy in 3 generations. Shirt sleeves to shirt sleeves in 3 generations. You may have heard the old proverb, quote, shirt sleeves to shirt sleeves in 3 generations. End quote. In Japan, the expression goes, quote, rice paddies to rice paddies in 3 generations, end quote. The Scottish say, and I love this one, quote, the father buys, the son builds, the grandchild sells, and his son begs. In China, quote, wealth never survives 3 generations. End quote. Around the world, there are many variations on this theme, all used to describe the tendency of 3rd generation to squander the wealth obtained by the 1st and 2nd generations. And with that lesson of morality, or whatever that is, with that lesson of life, let's get into this story about Isaac Hayes III suing the Trump campaign for alleged unlawful use of the song from his father. Obviously, there's a little more to the story, but let's go right back to the tweet from Isaac Hayes III, where he proclaimed victory from the court. Isaac Hayes III, at Isaac Hayes 3, breaking! The judge has given his opinion and order in our case against at real Donald Trump. The court acknowledges it's likely that post-June 6, 2024, uses were without a license and infringed on Isaac Hayes' enterprise copyright. Thank to the court for this order that came out yesterday in writing granting our injunction. Now we proceed to full trial. Our team at Liz Garner and at James L. Walker ESQ are filing an amended complaint with more counts and plan to press ahead in holding Donald Trump fully accountable for this illegal use. Thanks to at Attorney Griggs for standing with us as well. Now stop. Before we go any further, take the 3 seconds it takes to hit that subscribe button down there, drop a thumbs up, make sure notifications are turned on so you get notifications when I put out these types of vlogs. But breaking this down, you got Isaac Hayes III going after Trump for alleged copyright infringement because the Trump campaign at the rallies was allegedly without a license, and we're going to get to that, playing the song of Isaac Hayes III, father, a famous song. I guess some of us have heard it, some of us haven't. But the bottom line, what we are witnessing right now from a cultural level is the 3rd generation squandering what he inherited from the first 2 generations. Isaac Hayes III making sure to destroy the legacy of his father and making sure that his children have to beg as per the Scottish iteration of that rice paddy to rice paddy in 3 generations. But the bottom line, they filed an injunction, and as you could imagine, there's a little bit more to this story that only becomes clear if you take the time to read the actual judgment. In the United States District Court for the Northern District of Georgia, Atlanta Division, Isaac Hayes Enterprises LLC et plaintiffs versus Donald John Trump individually et defendants. Opinion and order. This is a copyright infringement case. It is before the court on plaintiff's motion for preliminary injunction and plaintiff's amended motion for preliminary injunction. For the reasons set forth below, the plaintiff's motion for preliminary injunction is denied as moot. Plaintiff's amended motion for preliminary injunction granted in part and denied in part. And then the brief background. This case involves the alleged infringement of the plaintiff's copyright during various campaign events. Plaintiff Isaac Hayes Enterprises alleges it has ownership interest in the copyright to the words and music of the song, quote, hold on, I'm coming, end quote, officially registered as, quote, hold on, I'm coming, end quote, hereinafter copyrighted work. At issue here is whether or not the Trump campaign, in fact, did not have a license, the requisite license to play the song, whether or not that license was revoked to the extent that it could be revoked. And what you see later on is that the Trump campaign argues that they had a lawful license up to a certain point when it becomes disputed, and after that point, although they say we still had a valid license because you had no right to terminate that license,
we agreed not to play the song on a going forward basis anyhow.
The court goes through the standard legal criteria for the issuance of a preliminary injunction and its color of right, balance of inconvenience. I'll go through the criteria very briefly, but we don't need to go through that. What gets really interesting is when it gets into the factual pattern of the case. Legal standard, quote, a party seeking a preliminary injunction bears the burden of establishing its entitlement to relief, end quote. Quote, to obtain such relief, the moving party must show 1, a substantial likelihood of success on the merits, 2, that it will suffer irreparable injury unless the injunction is issued, 3, that the threatened injury outweighs possible harm that the injunction may cause the opposing party, and 4, that the injunction would not disserve the public interest, end quote. And the court goes through the criteria and determines that, yeah, the campaign not using one particular song at future campaign events will not prejudice the campaign thoroughly such that, you could grant the injunction injunction that the plaintiff has established on a prima facie basis that they have a strong likelihood of success on the merits. The bottom line here, the Trump campaign said that we will not be using this song on a going forward basis, so there really is nothing to decide except for past use, so let's get there. The defendants do not contest that they have been using the copyrighted work at their events. Instead, they argue that they have a license to use the song and that the use of the copyrighted work in the videos they have posted constitute fair use. As to the license defense, the defendants have provided a copy of the BMI music license for political entities or organizations that authorize the defendant's use of the copyrighted work. Paragraph 2A of that agreement states that, quote, one or more works or catalogs of works by one or more BMI songwriters may be excluded from this license if notice is received by BMI that such BMI songwriters object to the use of their copyrighted works for the intended uses by licensee, end quote. Pursuant to that provision, BMI emailed the defendants a letter on June 6, 2024 that one of its songwriters for the copyrighted work objected to the defendant's use and that it was, quote, excluded from the agreement effective immediately. Despite that, the defendants continued to use the copyrighted work at events after June 6. Thus, the court finds that it is likely that the plaintiffs will be able to show that the post-June 6, 2024 uses were without a license and infringed on Isaac Hayes Enterprises copyright. The court cannot rule on the defendant's claim of fair use on the pleadings before it. By the way Isaac Hayes III was describing this, you would think that Donald Trump and his campaign went in and plucked out this one song, stole the rights to it, played it without authorization, but the bottom line as a factual dispute in this case is whether or not Isaac Hayes even owns the copyright or has sufficient copyright interest in the song to order the Trump campaign not to use it, because that song was included in a bulk of songs that they were allowed to use that they actually had licensed, and that is the very issue, whether or not Isaac Hayes even has the interest in the song to order Trump not to use it on a going forward basis. Page 4, ownership. The parties dispute whether plaintiff Isaac Hayes Enterprises owns any interest in the copyrighted work. The defendants argue that plaintiff Isaac Hayes Enterprises assigned its interest to an entity called Primary Wave Music IP Fund 3, quote, Primary Wave, end quote, and otherwise has not shown that it has any ownership interest in the copyrighted work. The plaintiffs disagree. They assert that plaintiff Isaac Hayes Enterprises regained control of Isaac Hayes' half of the copyright pursuant to 17 U.S.C. Section 304. That provision permits authors or their heirs to terminate the grant of a copyright after 56 years from the date on which the copyright was originally secured. In his declaration, Isaac Hayes III, president and CEO of Isaac Hayes Enterprises, stated that Isaac Hayes Enterprises legally terminated Universal Music Publishing and Warner Chappell Music's previous ownership interest on March 15, 2022, 56 years after the publication of the copyrighted work. This resulted in Isaac Hayes Enterprises regaining complete control of its 50% ownership interest in the copyright. Then, on March 1, 2023, plaintiff Isaac Hayes Enterprises entered into an agreement which assigned half of its interest to Primary Wave, resulting in each owning 25% of the copyright. The letter by Primary Wave and the declaration of Liz Garner corroborate this agreement. The defendant did not rebut this evidence. The court therefore concludes that plaintiff have met their burden of demonstrating ownership of the copyrighted work. So there is some dispute as to who owned the copyright, whether or not there was some confusion where the Trump campaign was using it, thinking that it was in the pool of songs that they were allowed to use. Isaac Hayes III revokes the authorization and then sues for copyright infringement. Basically, the Trump campaign comes in and says, look, we'll stop using it going forward. We don't care enough about this song, but you sure as heck are not ordering us to take it down for prior use, and the judge denied that aspect of plaintiff's claim. So what do you have in this case? Ultimately is the Trump campaign saying, yeah, we won't use it going forward. We'll go to a trial on the merits to see what damages, if any, you're entitled to. But the judge basically said, no, you're not ordering them to take down prior use because we have a dispute over that. And there goes your big victory, Isaac Hayes III. You have desecrated the legacy of your father for political purposes. Congratulations. Page 8, the court finds that if the use of the copyrighted work continues, the risk of association with the defendants and the harm that may ensue from that are actual and imminent and cannot be remedied through mere damages. Given the consistency with which the copyrighted work is used and the fact that the defendants' events are frequently aired on national television and other forms of media with widespread reach, the association between the music and the defendants is neither speculative nor remote. However, the court finds that, for now, the risk of harm from the videos of past events remaining online does not pose the same imminent risk. Accordingly, the court finds that the plaintiffs have showed irreparable harm for the future use of the copyrighted work, but not for the videos of past uses. That is one hell of a smashing victory, given that the Trump campaign had already undertaken not to use this song on a going forward basis, because who needs it? They've got other and better songs from other more deserving artists. And at page 9, on the other hand, the defendants focused their arguments on the fact that an injunction would restrict core political speech. There is no evidence to suggest that the inability to play the copyrighted work in the future will inhibit the defendants' political speech, especially considering that the defendants submitted a declaration stating that they do not intend to use the song at future public events while this litigation is pending. The court therefore finds that the balance of the equities favors the plaintiffs and that the public interest is served by entering a preliminary injunction barring the defendants' future use of the copyrighted work without a valid license. Conclusion: for the foregoing reasons, the plaintiff's motion for preliminary injunction is denied as moot, and plaintiff's amended motion for preliminary injunction is granted in part and denied in part. So ordered this 11th day of September 2024. But bottom line, smashing success. You got a preliminary injunction enjoining the use of a song that the Trump campaign had already undertaken not to use, and you did not get to take down the prior use because there is a dispute as to whether or not there was in fact a valid license and or whether or not there was in fact fair use. But good for you for desecrating the legacy of your father from rice paddy to rice paddy in 3 generations. And Isaac Hayes III, you are literally by your name the 3rd generation, so you might want to pay attention to that proverb that has various iterations throughout cultures and throughout time. And with that said, if you like what I do, you know what to do. Like, share, subscribe, hit the notification bell. If you want to support the channel, vivafrei.com for some awesome merch. I won't say the best merch, but it's pretty darn good merch. vivabarneslaw.locals.com for the best above average law community out there. More important than anything, exercise, eat healthy, sunlight, talk to people in real life, and now you know your vlog. Peace out, peeps. Booyah!
They're eating the dogs, the people that came in. They're eating the cats. They're eating the pets of the people that live there. And this is what's happening in our country, and it's a shame.